I don't feel able to translate everything that Anne-Laure said. I just say very quickly that the Paris Bar Incubator is part of the Paris Bar, and even if it's I think autonomous, and it's a structure that is meant to promote technology and new technologies and innovation among the legal profession and among lawyers specifically. So there are many actions that are currently being made in order to promote innovation. So with no further ado, I will let Axel introduce and chair the first panel.
Hey, hi to everyone. Welcome this morning. Do you guys have a good coffee? Yeah, good. It's very early, so you guys are definitely extremely courageous. So my name is Axel Edida. I sit with L'Oréal, and my core interest is in data. And I'm a total rebranding from Ricardo Cortes-Monroy, who unfortunately could not make it to Paris this morning. So I'm extremely happy to have the chance to moderate this fantastic panel, where we are going to address a central issue to big data is how it is affecting consumers. Big data delivers a breadth of information on consumers' behaviors and opinion, which can significantly trigger the way we can define what consumers are exactly contracting, how they are being protected, and finally, how digital platforms would need to be regulated. So we have around the table Professor Ben-Shahar, currently director of the Coase Sandor Institute for Law and Economics, co-reporter for the American Law Institute Restatement of Consumer Contracts, and who holds a fantastic bi-weekly column in Forbes with fantastic subjects about privacy, market forces, and he will be presenting how to interpret contracts via survey and experiments. On my left-hand side, Professor Annelise Siboni from Université de Louvain, professor of European law, will be introducing on how to protect consumers against unfair use of data with a perspective on the EU consumer law. And ultimately, Professor Celia Zolinsky, University de Versailles, Saint-Quentin, Paris-Saclay. So Paris-Saclay is a fantastic place where we hold all our universities and technology institutes. Member of the French Digital Council, the famous CCNUM, Conseil National du Numérique, and will introducing big data and consumer law regulating online platforms. So we have an audience which is courageous enough to start a Saturday morning. So I'd like to give the opportunity to one or two members of the audience to introduce themselves so we know to whom we are talking to. Madame. You. No, I'm one of the organizers. Fantastic. And
yes, I'm Associate Group General Counsel at Capgemini, large IT company, French and American.
Gentlemen?
I'm a PhD student and I'm working on election systems and the internet.
Fantastic. Well, thank you very much to be here, and let me introduce, with no further delay, Professor Ben-Shahar. Thank you so much.
Thank you.
So yes, thank you very much for coming so early this morning. I did not expect such nice turnout. So I'll speak for about 15 minutes. I will present a new idea that I'm working on. But before that, I want to say a couple of things. First of all, my talk is not, to some people it might be a little disappointing, it's not about how big data, consumer big data is affected and regulated. It's using consumers and consumer knowledge to within the law. It's kind of outsourcing some of legal decisions to consumers. And so that's the idea I'm going to talk about. So it's a little bit different than the title of the. So in some ways you were a little bit deceived by coming here to hear about something big data and consumers, and I kind of flipped the directions, consumer creating a law. That's one comment. The other is also, before I go into the paper, there was a lot of discussion yesterday, most of you were here yesterday, about big data replacing legal reasoning, replacing judges, replacing lawyers, and there were some fantastic examples of how this is being done. I was blown away by some of the things that I heard yesterday. There was a lot of pushback also from both from the philosophers, political theorists, lawyers, saying many things will be conquered by big data, but not the legal profession. There is something special about it. So I prepared one slide to. This is for 100 years ago when Henry Ford and Mr. Daimler introduced the cars in two continents, and it was called a horseless carriage. People wanted the horse. So you see this is not a real horse. This is how early cars, some cars were created, so that and people said the horse is here to stay, but automobiles are only a novelty, a fad. Even Mr. Daimler predicted that there will be at most, in the future, 1 million cars. This is not something that could become very popular because you don't have enough chauffeurs. So just a little bit of perspective, maybe with the advent of the autonomous car and big data in general, we are underestimating how quickly this will conquer our environment. But the paper today, which is by the way co-authored by my colleague and friend Lior Strahilovich from the University of Chicago, is about something a little bit different, and that is, I'll try to explain it with a couple of examples. So, what is this? This is a term that I cut from just yet another long list of terms and conditions. When you go on the internet to any website, you go at the bottom and it says privacy policy or terms of service, and here is the language. You do not have to submit anything to us, any of the information you give to that website. But if you choose to submit any user content to the site, it will be deemed non-proprietary and non-confidential and may be used by us, our affiliates, or others without restriction. What does it really mean? Who can this company, by the way, do you know which company this is? Every company. But Axel, you should know which company, you probably wrote this. So when he told me that he's going to chair that, I like L'Oreal very much, not that I no longer use any shampoo, but they created a lot of trademark cases and they fought for their trademarks. And I taught some of these cases. So there was a great opportunity to meet a top lawyer from the firm. This is kind of a standard thing, and there is a question, if there one day will be litigation because L'Oreal takes information and gives it to, I don't know, some health insurance company, or is this an affiliate? They give it to a bank, is this an affiliate? Court will have to decide because somebody will, in the US, will sue. And they will spend years, probably, arguing about what affiliates mean, or any other word here. I'll give you an example from real litigation. This is just me saying somebody might sue, but people do sue, and look at the Google policy, Google terms and conditions say that Google, Gmail, reserves the right to pre-screen, review, flag, filter any or all content from any service. This is when people sign up for Gmail, Google gives it for free, but they scan the content in order to tailor personalized ads. If there is no consent for it, if people do not give Google consent to scan the email, this is a violation of many laws in America, including wiretap laws, the prohibition against wiretapping people. So there must be consent, and this is supposedly the phrase in the long contract in which users gave their consent. Yahoo.com also gives email for free, and they say something similar. Automated systems scan and analyze all incoming and outgoing communications to match and serve targeted advertising. So they try to convey the same message but in different language. Both companies, Gmail and Yahoo, were sued in class actions by consumers, and if consumers win, the damages are astronomical because for each email that was scanned, I don't know, $1,000. You know how many emails people send, so do the multiplication. So they've been fighting over this for several years. Actually, it was recently resolved in some kind of settlement. But the plaintiff said that this language is not, they don't tell us that they're scanning our email. That's not what it means. Reserves the right to pre-screen. We don't understand what that means. Do you understand what that means? And so in the court spent 5, 6, 8 years on the Google litigation. Lawyers, big law firms, racked up, billable hours. I would say, I don't know how much this litigation costs, but tens of millions of dollars and a lot of federal court time, and it's still ongoing. The Yahoo litigation was eventually dismissed, Yahoo won. The court determined that this language means that Yahoo has the permission from users. Wink, wink, right? We know that users don't really read this. What does this concern? But that's a different question. Under the law, if this sentence means we have the right to scan your email, then Yahoo is fine, and that's what the court said. So in the Google litigation is still going on because the judge said the language is ambiguous. I cannot determine without a trial what it means. This is after years of fighting pre-trial and all the millions of dollars. So now they were supposed, usually when the judge makes this determination, there will be settlement. So most of the fight is in the pre-trial. Okay, so my colleague Lior looked at this in another study and said, well, that's what the judges say, that's what the lawyers say, but let's ask consumers what they think it means. So we did a study and asked them a survey question, showed people that language that I just showed you, and asked them, would your agreement to this provision allow the email provider to scan the contents of the email you send and receive and show you personalized advertisement? Yes, definitely yes, probably no, definitely no. Choose what you need, sit for there for a minute. You got 3,000 people in a kind of consumer survey and got the results, the following results. There's a little bit of things that jumped here, but you see that definitely allowed and probably allowed is about 2/3 combined. 66% of the audience, 65 to 66% say, yes, Google can do it. Only 34% say, no, Google cannot do it. 2-to-1 ratio. For consumers, it seems pretty clear that that's what it means. And this was kind of surprising when you think about it, because first of all, the fact that people say that that's what it means, despite in a second question saying that it's a very intrusive policy and they don't like it. But they concede that that's what it means. And they're also, when you show them the Google and Yahoo text, they say the same thing. There's no difference in the outcome. Despite the fact that the court said viewed one language one way and the other language the other way. And so the thought that came to Lior and I when he showed me these results is that consumers sometimes read contracts in a very different ways than judges and lawyers do. And rather than use this insight in this one litigation to criticize the result, why not develop a more general approach to how to read contracts? Especially, let's start with consumer contracts. All these privacy policies and consumer boilerplate and bank contracts and all the forms that consumers always receive with legal information, instead of the law determining what it means, consumers should determine what it means through surveys. Now, for me, the inspiration was from thinking how disputes in the trademark area are resolved. When a company puts out a name or a logo that another company thinks is confusing, when they call their hotel, their motel, Next Sleep, McDonald's say, wait, people will think that it is our McDonald's, because everything with Mac in America is McDonald's. So McDonald's might say, people might be confused to think that we are sponsoring this, that you are affiliated with us. And they would sue. This is all a real case. And how would the court resolve this? They would ask the parties to bring consumer surveys. When you see the word Next Sleep, what company comes to mind? And if enough consumers say McDonald's, then there is confusion. And because there is confusion, the name Next Sleep is not allowed. So consumers are asked to interpret these messages, advertising, trademark, pre-contractual messages, things that are told to consumers about the contract. Our idea was consumers should also be asked what they understand from contractual language. That's what the law is trying to do, to enforce the contract the way it was written for the consumers. So why not ask the consumers what it means? So here's an example from an insurance contract, insurance contracts are very long and very confusing, even to judges. They spend a lot of time fighting over the ambiguities in the contract. So that's, this is a sentence from a homeowner's insurance contract. Most people, when they insure their homes in the United States, they own their homes and insure, they also get coverage, not just for fire and theft, but also if there is a guest or somebody is injured in their home, that covers their liability, tort liability, to someone that is injured. But the policy does not apply to bodily injury, that's what it says, or property damage arising out of business pursuits. So if you are a doctor and you have a clinic in your home and you do perform some kind of treatment to a patient and you get injured, your homeowner's insurance will not cover it because it's a business pursuit. And the same if you're a therapist or do any kind of work at home. The idea is to exclude it. They will cover you, but you have to pay separately for additional coverage for business pursuit. The thing is that this sounds very simple, but there is another sentence in the policy that says, except for activities which are ordinarily incident to non-business pursuits. Sounds funny, huh? You think, to many French people, this might sound like gibberish. To to English speakers also. This begins to be a little bit complicated. What does that mean? So remember, we have here an exclusion, and an exclusion to the exclusion. And that's insurance contracts have these layered triple and quadruple negatives. Very hard to understand. And so, this is litigated dozens of times, hundreds of times, on different questions that come up. And in every single US state, the following question has reached at least the appellate courts and many of them, the Supreme Court of the state, several times. Is babysitting a business pursuit? You get paid, but it's not really a profession. So in a case, for example, that a typical case, a relatively low or middle income person stays at home with her child, and the neighbor brings a child regularly every morning and drops off the child for the babysitter to take and pays. So it's not really the job of the housekeeper to be also a babysitter, but since she's at home with her child, she's also being paid to keep for another. Is what happens when that baby, the neighbor's child, gets injured from something that was going on? For example, a meal was, hot water was heated to cook something and spilled and caused some injury to the neighbor's child. Is it covered by the insurance policy? And I have to say that the answer is kind of not clear. It is maybe yes, maybe no. Some judges read this to say, this language, say no, it's a business pursuit. Some judges say maybe yes, because what is activities ordinarily incident to non-business pursuit? So non-business pursuit is babysitting my own child. Incidental to that, I also take another child. Is this incidental? Not clear. But in insurance law, there is also a rule that says that if the policy is not clear, the policyholder wins. The insurance company loses. Interpret against the drafter. Contra proferentum. So we asked, in the study we asked consumers to see if they understand it any differently, and we tested two languages. The real language from the contract. We told them a story about the babysitter. We showed them this language. A shortened exclusion that just says the first sentence without that very confusing second one. This is the second one in the bottom is not in the contract. That's not what the contract says. It's only part of what the contract says. So it's a more synthetic case. And these are the results that we got. Let me just briefly summarize it. On the two left columns, you see the frequency, or importantly, the percentage of people in the original exclusion. And you see that people covered versus not covered is roughly equal, or even more people say that it's not probably not covered. 47% versus 34%. And a lot of people, 25% say it's not clear. These are, by the way, people who, what they say, people say. We, again, did a consumer survey of 3,000 consumers. No, yes, 1,300, 1300, 1,300 consumers, representative of the US population, through a consumer survey company that is professional at identifying such populations, and we wrote these questions to them, and that's the results we got. And then when we showed to a different group the shortened exclusion, the results changed. Now people are saying it is probably not covered 57 or 58% as opposed to only 27% saying that it is covered. What do we see here? We see that the language, both the language that was tested, the types that we tested, or the original language in the contract was more ambiguous than it needed to be. The company could have written an exclusion that would have been much clearer. It made a significant difference on how people interpret, the consumers interpreted it, and the consumers, the insurance company should lose in the original language, first because it is ambiguous. We saw that it came not quite 50-50, but close enough to that. Too many consumers thought that it was, that the insurance company should lose, and that if it were to change the language, it can get its result, notwithstanding the fact that we are asking consumers about insurance. And most consumers don't like insurance companies. They nevertheless say, side with the insurance company when the language is clear. Okay, so the question that the core, and I'm going to wrap up, that the paper asks is, which future for contract interpretation? Lawyers and judges looking at the language and saying what a reasonable consumer would understand, or consumers are asked in a survey to say what they understand. They actually understand. Now, this is part of an idea of how to outsource or to crowdsource the law. Instead of people trained in legal reasoning explaining to us what the language means based on normative criteria. What good, if we interpret it this way, that will increase the efficiency of the market, or will increase the fairness of the market, or will vindicate some consumer protection idea. They have all sorts of good rationales and justifications for the interpretation that is offered by lawyers and judges. Instead of that, I'm proposing something that is, in a way, thoughtless. Ask people on a survey in which they are paid $1, $3 to participate, and they're spending a few seconds and not really putting a lot of thought into it. And many of them are just answering randomly. Ask them what it means, but throw a lot of people at it. Use a lot of power. And that would give indication without having to do the exercise of thinking or do very little bits of thinking, but enough thousands of consumers would give us the answer, give us a clear answer. Now it is the main justification for it is that it is very cheap and easy. These surveys cost us $3,000 to do. That's, 4 hours or 3 hours, you guys will know, of an American top law firm lawyer's time. And they've been finding out that for years. So this is really cheap. I know it's not going to be just $3,000. We need somebody to design this, and lawyers have to fight over which survey is more. Yeah, but part of what we're suggesting in the paper is that people will write in the contract that in the event that they have a dispute, they don't want to go to court and to fight the interpretation battles the way that is that everybody fights it nowadays, because it's very costly. So if we have a dispute, we want the court to resolve it based on the survey method, and in fact, we want the Ben SHAHAR Strohilovich startup firm to provide the survey. I'm just kidding, we are staying in academia, but you can imagine that people can choose a specific, reliable, neutral survey company in the same way that they choose arbitration over litigation. It is to save the cost and to make things less accurate, more formalistic, but quick and cheap. So this is the vision that we have for consumer interpretation of consumer contracts and how legal disputes about them ought to be resolved. I will just say, most of the disputes that are in class actions about consumer contracts are about interpretation of language. And so this would greatly simplify litigation in this area. And the paper also, the article also thinks or ponders the possibility of expanding this to other legal contexts. First of all, to merchant contracts, commercial contracts, maybe survey sophisticated lawyers what the language means in a sophisticated negotiated contract. What about other legal texts that are not contracts? Statutes, constitutions, not necessarily wedded to the idea that these ought to be interpreted by people rather than by learned judges. But what I'm saying that is that consumer contracts, which are written for people, and where the law says the meaning should be the meaning that a reasonable person from the intended audience understands, those contracts at the very least should be interpreted by the way actual people really understand it. Thank you.